Well, welcome everybody to the Parental Alienation Awareness Day conference brought to you by Parents Beyond Breakup. We've been running since Father's Day 1999, keeping mums and dads alive and in their kids' lives. Parental alienation can be an emotive topic, and you may hear differing views or experiences today. If you have any strong emotions coming up or want any further one-on-one support, please call us on our helpline. It's open 7 days a week. If you're within Australia, the number is 1300 853 437.
Our next panelist will be Adam Jones, who will be sharing some insights from a family law perspective. Specifically, Adam will be speaking on how courts and professionals view the matter of parental alienation.
Thanks, Pete and PBB, for inviting me to speak here today. This is obviously a very important subject and something that I've been grappling with for the majority of my career. When I was putting together some notes for this segment, it dawned on me that the words parental alienation are just never used by a court. It's certainly something that It's certainly something that everybody knows exists. Professionals use it, and of course our clients use it, because those are the words that describe what is being so clearly observed. Yet you'll never hear it coming from the bench. And there are also words that you don't often see come through in an expert report. That doesn't mean it's not considered, and that doesn't mean it isn't at the back of a lot of experts' mind and also of judges' minds. But where it falls into the law is within the realm of either of psychological abuse, which is a form of family violence, which is one of the things that the objects of the Act needs to protect children from. It is also, and I will state that the law in Australia has moved backwards insofar as its support of shared parenting. Previously, one of the objects of the Act, or one of the objects of the parenting part of the Family Law Act, was certainly to protect children from risk, but also to promote a meaningful relationship between a child and their parents. Those words have been removed. What does remain, however, is an object that the Act needs to give effect to Australia's obligations under the Second Hague Convention in 1989, and that Act does include the words meaningful relationship with both parents. The removal of that section of the Act, I think, is an indication about how much weight or how much importance the legislature, at least, and perhaps some members of the full court, put on promoting a meaningful relationship with children. But it is certainly something that is subordinate to protecting the children from family violence and physical violence. Coercive control seems to be the largest focus now. The problem with dealing with an alienation situation in court is that it never comes alone. There's always allegations on the other side. Generally, look, in my experience, alienation or estrangement or behaviour, children being resistant to spend time with an alienated parent, is looked at as a symptom rather than the problem in of itself. Generally, the court will deal generally where children are reluctant to spend time with dad, refusing to pretend changeover, reluctant to spend time with grandparents, or saying to experts or psychologists that they are fearful or that they're fearful of dad, don't like dad or mum, because there's many mums that are suffering from alienation. It is accompanied by allegations from the alienating parent that the child has witnessed family violence, the child has witnessed coercive control. There has been the child's behaviours as a result of a long course of behaviour by the alienated parent, and often a court will need to deal with those allegations to rule them out or not, before questions of alienation can be dealt with. One of the problems in the way that matters proceed through the Federal Circuit Family Court is that findings of fact, so decisions about what was true and what was not true, can't be made until the end of a hearing, an end of a litigation process that could have taken years. And while you're going through that litigation process and the court is making decisions about interim decisions about what sort of access each parent should have or where children should live, along the way, allegations that have the potential to be true are treated as possibly true, because the court will say, well, we're doing a risk assessment at this stage of the proceedings. We can't rule anything out, and so we need to act cautiously. And as a result, that generally puts the allegations of risk made by the alienating parent on the same level as the allegations that this is a course of alienation by the alienated parent. What this then leads into, which I think is the biggest hurdle that parents facing this situation find when they're trying to deal with the matter through the litigation process, is delay. If that delay becomes compounded, if there is no access if there is no time being spent with the child, the only way to eventually prove that this was an alienation situation, that the allegations against you were not true, is to have an expert recognize it as such. And that expert needs to go so far as to what the expert needs to do, because one of the changes that have been put into the Act, there's been a slimmed down version of Section 60cc, which is how a court determines what's in a child's best interest, children's views have been given greater weight. So what an expert needs to do to assist in an alienation situation is to say that the children's views should not be given significant weight. And that's essentially code for the child has adopted the alienating parent's views, and therefore you can't do what the children are saying because the children aren't able to think for themselves. The second thing the expert needs to do is recommend, and even though I will say it's quite unusual, it's quite rare for a court to change the residence of a child, but that is the only option that a court has in a serious alienation situation. The other tools that the court has at its disposal are ordering family therapy, essentially ordering family therapy and other psychological interventions. However, a court really needs to have the threat of a change in residence hanging over an alienating parent in order to use the soft power of the court to encourage that parent to change or to stop the alienating behaviour. I don't have much time, but I just thought it might be useful just to give a couple of examples of how these situations have played out in cases that I've run. There was the most successful, or the one that taught me the most about alienation, and I've had a few of these, are cases where there were property proceedings. Essentially, the dispute started about property. The other side sought an unreasonable property settlement, and the only way to achieve, or for that, what they were asking for to even be in range, was for the other parent to have full custody of the children, so that there was a big property adjustment. That was the beginning of it. I'm not going to deny that both of my clients in those situations did some silly things, perhaps involved the children a little bit in the conflict, and perhaps let their emotions get the better of them. But what resulted were, and this in both of these cases, it was 3 boys getting to the point where they threatened self-harm and harm to the father if they were to have to spend time with the other parent. This is in both of those situations. This was a father that had very close relationship with all of the children, and the descent into absolute refusals to have any relationships happened very quickly. In all of the cases, we went through a long process of trying to have a successful psychological intervention, and we had multiple expert reports in both cases which said that mum is just completely unwilling to change her views. The children have completely adopted their narrative. The children have rejected the entire paternal family, notwithstanding the paternal family having done nothing. to justify there being any rejection, to the point where the children, in one of the cases, the children actually attended school with cousins, and they were previously seeing these cousins every weekend, and it got to the point where they wouldn't even acknowledge them in the playground. So it got that severe. In both of those cases, what the fathers did was remained visible in the children's lives. So continued attending all of the children's sporting matches, even though that resulted in letters coming back from the mother's solicitors saying that he needed to stop attending. And there was an unsuccessful application to restrain him from attending. He continued to do so, and this was over a period of years as the case went through. Eventually, when the property aspect of the matter settled, one day the children simply came back to him. This was after they were all over 10 years old. The eldest was 15 years old. In both cases, it was led by the elder child who was beginning to come of age. But what those cases taught me is that when you're in an extreme alienation situation, but your intuition tells you that your children still love you, you had such a close relationship with them, that what occurring simply doesn't make sense. The fact that these dads simply did not give up and signaled to their children so that they could see them every week at these sporting games, that they were still there. That was enough to signal to the children that when they were ready, the door was still open. Another example I've got at the moment is a case where there is where a parent is trying to relocate from New South Wales to Queensland. And part of that relocation is one of the strategies that is being used court orders to try and limit, in this case it's the father that I think is being alienated, limit the physical relationship that the father can have with the child. So there have been a number of applications and an attempt through a psychologist report to suggest that there is something untoward about the child, and the child's 5 years old, the child sleeping in the father's bed from time to time, or the father sleeping, or the father being in the room while the child is bathing, or the father not closing the door while the father is using the bathroom. These are small things that seem to be very banal and very ordinary in a domestic situation. But the attempt to remove this, to somehow stigmatize these very normal aspects of having a close relationship with the child, I have advised him to fight tooth and nail. These are things that should not be agreed. These are behaviors that should not be stopped. And these are orders, and they might seem innocuous. It's proposed that he just consent to it on a non-admissions basis. The simple existence of those orders, or the simple removal or denormalization of those behaviors, I regard as the beginning of an alienation situation, and the beginning of an estrangement that can grow over time. Another example of something that didn't turn out very well was a case where there was and it sounds like I act for a lot of dads, and I do, but these behaviours equally apply to mums that are going through it. But a father that had his 11-year-old girl go from spending every second weekend, half the school holidays, and a bit of extra time with him, to a point where she was physically cutting herself if she needed to, if she had to see the father. And this all occurred over a period of 6 months. This was a case where the parent, the alienating parent, had been diagnosed as having an extreme attachment disorder. She was obsessed with being a victim of coercive control by the father. She had spent a long time psychologist shopping to try and find an expert who would vindicate all of the allegations that she was making against the father. And these allegations of coercive control went right back to the 2000s. They'd been separated for 10 years by this point, but she was still obsessed with this narrative that he was a mendacious individual and that his coercive control. She never said there was any physical violence or any threats of violence or anything like that. The coercive control was very much in the tone that she perceived he spoke to her with. But she was obsessed with having this narrative accepted as true by experts and by the daughter in this case. Unfortunately, this was something that was recognised by multiple experts, and it was a case where the court, on an interim basis, accepted that there was, and even though we didn't use the word alienation, accepted that the mother's behaviours were likely to be very psychologically damaging to the child. We got to the point where we got an expert report that recommended a change in residence, and it came to an interim hearing, and we went in with all guns blazing. Unfortunately, in this matter, after receiving, what happened just before the interim hearing is that the child attended a psychologist, and this was the court-approved psychologist, and said that she was going to kill herself if she had to see the father, and she had cuts on her arms. Now, the mother was in the room when this was said. The mother said that she'd done that to herself. The child had a cat, but the psychologist put in her notes that the child presented with images that are consistent with self-harm, that she said the magic word, "I'm going to kill myself." And when a child says that they're going to kill themselves if they have to spend time with dad, the court does not force a change in residence. The court slows everything down. And unfortunately, that was a case where, and also dad was running out of money, and he wasn't actually in a position to have the child come into his care. Mum was being funded by very wealthy parents. That was unfortunately a case where he gave up. So sorry to leave that on my final example to be a negative one. But look, these cases are incredibly difficult. They are fraught with parents that are sometimes willing to do anything, no matter how much damage it will cause to their children, in order to ultimately see their narrative that they were the victim, that the other parent was as bad as they were making it out to be. The accepted narrative by the courts and by the children. And there are many solicitors out there that will happily accept $100,000 or so to beautifully tell narratives like that. One other thing that I'll say in terms of hurdles is that the biggest hurdle that I find in family court cases are where you might be running an alienation argument in court, and the other side manages and criminal charges emerge, and this happens reasonably regularly. And the problem with criminal charges is that once they've been laid, the criminal process has to complete before the family courts will go through their process of risk assessment. And it's particularly so where there's been an allegation of sexual abuse. So when there's an allegation of sexual abuse, if it's true, it will result in a no-time case. If it's false, coaching a child to make a false allegation of sexual abuse is recognised as an extreme form of psychological abuse, and so it's going to be one or the other. But unfortunately, criminal cases take time, and that then leads into the other enemy for alienated parents, which is delay. So I guess the advice when criminal charges have happened is to try, if at all possible, to have them resolved as soon as possible, because family court cannot proceed while they're outstanding.
Thank you so much, Adam.